slowly going to be trickling in, but we figured we may as well get started. Thanks to everybody for logging on today. We are very lucky today to be joined by Alex from Sprintlaw. For those who don't know, Sprintlaw are an incredible expert business lawyers that are stationed all around Australia. And this webinar is also a series in partnership with Friday, who do amazing stuff as well for small businesses and financial support. So I'll pass this over to Alex. Feel free to ask questions, put your hands up, do all those kind of things, and I'll just be over here, just sitting here on my own. Over to you, Alex.
Awesome. Thanks so much, Josh. Let me just quickly screen share. Can everyone see that okay? Awesome. Well, hi, everyone. As Josh mentioned, I'm Alex. I'm the co-founder of Sprintlaw. And this session today is entitled Legal Requirements for Startups. Before I get into the content, just to give you a bit of a summary of who we are, we're an online law firm. We operate all around Australia and some other countries too, made really for startups and small businesses. We're a bit different to traditional law firms. You know, your traditional lawyers will charge you by the hour for advice. Our models completely fixed fee. We give an upfront quote for your services before you start work with us, and we operate in pretty much all the different areas of laws that smaller companies may need help with: setting up companies, registering trademarks, intellectual property, employment law, and more, many of which we'll be talking about in a moment. We have an optional membership. A lot of startups sign up to it. It's pretty cheap. You get access to a helpline where you can call lawyers whenever you need help and make some of your own simple docs yourself and more. And we in fact have an offer which we do for a lot of startups that are part of Startup Accelerator Incubator programs, which we're very happy to extend to people part of LaunchVic. So yeah, you can get our first 12 months of a membership for $200, which is a pretty cheap way to get access to legal help. So again, if off the back of this presentation you have questions or you don't have lawyers and you'd like to get some, it can be a good way to kind of get started. So you can just email our team and mention that you're part of this program, or you can, take a screenshot of that little QR code there if you want. And finally, I always like to mention we're also a startup, and I, as a founder, am obviously a qualified lawyer, but also a founder myself, and I've kind of been on the journey from starting, with no money and a co-founder working out of an apartment, all the way up to kind of raising 3 or 4 rounds of capital and growing to a couple of countries. And so our team kind of understands startups and how they work, and it helps inform our advice. So with that in mind, this is a list of what we're going to talk about today. I'm first going to start with some basics: setting up your company. How should you structure your business? What are some common ways of organizing things? I'll touch briefly on industry regulations that may affect your business, contracts, the point of them, intellectual property, data and privacy, and then building a team. And I think this is a good set of initial kind of legal areas for people to be aware of and learn a little bit about. As I'm going through, if you have questions, feel free to kind of drop them in the chat on Zoom along the way. I'll leave a little bit of time at the end, but I also I don't mind kind of answering as I go through, or if you prefer to put up your hand using I think that Zoom has like a raise your hand feature. You can also do that if you would prefer to speak than type. So yeah, do feel free to interrupt me if there's questions that you want to ask as I'm going through. Before we get into all that stuff, though, I always like to start with a little bit of a philosophical question, if you will. When is legal help needed for a startup? And people founding startups have different levels of knowledge of what lawyers do. And oftentimes it's thought that I need to kind of tick some boxes. I need to make sure I'm complying with the law in my business, and that's when I'm going to speak to a lawyer. It's a compliance exercise. I think savvy business owners and founders realize that lawyers can do more than just be an assistant to the box ticking, if you will. Really, I like to think of us as sort of primarily in the business of risk management. We are specialists in a particular form of risk, which is legal risk. Now, when you're building a business, you're obviously often focused on how am I going to grow my business? How am I going to manage my expenses? How am I going to be profitable? How am I going to survive? How am I going to have a positive competitive strategy? But equally, you should be thinking, and also, what are the risks? What are the risks? What things could go wrong? And some of those risks may have nothing to do with the law. It may be, what if my IT systems crash? What if someone, gets injured on the job? Some of those risks may be legal in nature. What if I'm sued? What if I'm liable? What we do as lawyers is we have tools, things like contracts, things like policies, documentation, procedures and rules we can help put in place to reduce risks and enable you to sleep easier at night or run your business better. Some of these things are not necessarily required by law. In fact, a lot of what we do are not necessarily required by law, but they're a tool of risk management. And I have this kind of classic risk matrix people have probably seen before, which I also like to show because lawyers are expensive. I mean, we're less expensive than your traditional lawyers because we know that startup companies don't have that much funding, but we still cost money. And the reality of the situation is when you have limited budget, you got to work out, what am I going to spend it on? Am I going to drop $40,000 on lawyers and then run out of money? Or is there a way I can spend a lot less, a few hundred, and live with some of the risks? And I think that's a reasonable way to think about your legal budget, your legal spend, and in fact, your overall risk management spend. What you want to be working out as I'm talking through these different slides is, for my business, what are the big risks that are quite likely to occur? And what are the smaller risks that probably don't matter yet, but may matter in the future? And the things that are high risk and or likely to occur are the things you want to get advice on and get support with. The things in that latter bucket, maybe you can wait till you're a little bigger to deal with. So for example, we'll talk a little more about this in a moment, but your brand protection or your founder agreements with other founders, things like these are pretty high risk if something goes wrong. If there's a falling out between business partners, it can be business ending. If somebody steals your brand name and starts using it, it can be business ending. So those things are a higher risk, and therefore things we typically recommend people deal with early on. Workplace policies, when there's two founders working in a company, putting together a 200-page document covering workplace bullying or whatever, at this point in time, probably low risk and not something you necessarily need to do. But as you start to grow a team, it may shift in the risk matrix. So it's important to think about, with all the different legal tasks, where does it sit in the risk matrix and what should I be focusing on now? And again, build the muscle of risk identification in your business when issues come up. What are these bigger risk issues that need legal advice? So I think risk is a really important time when you may think about legal help, and we have these tools to help reduce risk. The other thing I also like to mention is, bigger businesses know this, but often smaller companies miss this. Lawyers are actually, in addition to risk management, also helpful at enabling you to get a good deal. And the reason for that is because, we are often in the business of drafting documents, contracts, and things like that. And it means that over time, we've seen many, many different arrangements, types of deals. We know industry standard cancellation policies. We know late fees if invoices aren't paid on time. We know how to design referral partnership arrangements in clever ways that business owners might not have thought of because we've just drafted so many. And so one thing you can do, sometimes, again, you may not need legal help to do a handshake agreement with the business partner, but you may want legal help because even though it may cost a little bit, the lawyer can help you design a clever arrangement that achieves your business goals in a way you hadn't quite thought of. So for important deals as well, that could be lucrative for your business, another time to consider getting legal help for important contracts and things like that. So there are two areas I just always like to flag to contextualize what we're going to be talking about. Okay, so let's talk a little bit about the more substantive legal stuff. Just beginning with setting up a business. So in Australia, when you are setting up any kind of business, there is a requirement that you have to do some registrations. Unless it's a hobby, you need to register an ABN in Australia, Australian Business Number. And optionally, if you're conducting a business, you can register something called a company as well. And there's a few other different business structures for different circumstances. Oftentimes, people that are operating at a small scale, they're just one person, we'll start off with just registering an ABN and operating as what's called a sole trader. It's quick, it's easy, it's cheap, it's free. You can just do it online sort of instantly. You get a business number. You're now allowed to go out, issue invoices, and operate a business if you do that. I don't have it on this screen, but if you're working with 2 or 3 people, you can form what's called a partnership structure, which is similar to a sole trader, but it's just kind of like a few sole traders working together. Again, quickly and easily, you can get an ABN and start operating. And people choose to operate as sole traders and partnerships, often if they're doing a side business or kind of working for themselves, or it's kind of in the early stages. We, though, as lawyers, pretty much recommend that every serious business set up a company to operate their business. And a company has a ton of benefits over these sort of quicker, cheaper sole trader partnership routes. One of the main benefits is, when you set up a company, in legal terms, what you're doing is you're setting up a separate legal person. It's like a separate being to yourself. It will operate the business. The company will have directors who are sort of like the arms of the company, of the fictional legal person that can sign documents, operate the bank account, and then it'll have shareholders that are kind of like the body of this person that kind of own the legal person, but it is its own person. And that means when you're going out, when kind of doing business under the banner of the company can, sign contracts, employ people, end up in potentially risky situations where it's liable, and it can get in trouble. But typically the directors and shareholders, with some exceptions, have what's called limited liability. They're protected from ultimately many of the risks of the business. When you're operating as a sole trader or partnership, it's really just you that's operating the business. So if you make a mistake with a client and you get sued, your home could be on the line, your car could be on the line. All of your personal assets are not separated from the business. There is no separate legal person called the business. So from a risk management perspective, very, very much we recommend the company structure as sort of a shield between yourself and the business. And again, pretty much every serious business is set up as a company. There's a ton of other benefits. It makes it a lot easier to raise investment, employ staff, and grow. So long story short, you should set up a company for your business at some point, as soon as it kind of gets serious, if you haven't already, because it's quite risky to run it any other way. Now, there are, people may be aware, more sophisticated versions of company structures that you can do with your business. And again, startups that intend to raise investment or scale do more sophisticated things with their business structure often. And I'll explain a couple of the common structures or setups that are used for startups on this slide. On the left, we have the kind of straightforward approach. And I'll use our company Sprintlaw as an example. We could be set up as Sprintlaw Pty Ltd, a private limited company, which is a common company structure that's used. The fictional legal person, would be owned by me as founder 1, my co-founder, founder 2, and then our investors if they invest in it. And then we have this company structure, Sprintlaw Pty Ltd, that goes and opens a bank account. It employs staff. It enters into contracts with clients. It registers trademarks. Fairly straightforward, simple, easy to set up. The challenge, of course, with that is, even though we as the founders and our investors are protected from the end employees and clients, as I mentioned on the previous slide, because we have this company structure, over time, this company itself starts to become pretty valuable in its own right. I can say for sure that Sprintlaw Pty Ltd at this point in time is a lot more valuable than, me, Alex Solo, and my personal assets. So over time, you actually want to start protecting the assets of the company as well from risk, not just yourself. So oftentimes companies will set up a dual company structure where they'll set up another company. So the company that they ultimately own is called a holding company, and it is like the safety deposit box that will hold, all of the cash of the business, or a lot of the cash of the business. It'll hold the intellectual property, the brand name, anything that's really, really important will live in this holding company. And then you'll set up another company called an operating company that's owned by that holding company. And that's the company that will go out and do risky things like employ staff, enter into contracts with customers, and so on. And so you've kind of got this double shield of protection. If the operating company gets in trouble, it gets sued, it has some kind of liability. People typically will have a claim against the operating company, but it may not have any of the assets because they're hidden in the holding company. So, let's say you're running your startup, everything's going well. Suddenly in year 2, something goes wrong with the client and you suffer a massive lawsuit. If you're in the single company structure, could be business ending for you, that lawsuit, because if they're successful, they can come after all of your assets. If you have this holding company structure, the lawsuit may damage your operating company and you may be forced to fold it down, but you can then set up another operating company and continue operating the brand. Of course, there's some exceptions and so on, but typically that's the thinking in terms of having these 2 company structures. It also makes it easier to expand and keep a neat structure. So you may, if you want to grow into other countries, typically it's a requirement that you'll set up a company there as well. So when you have this dual company structure, you can start to have these parent-child relationships between your companies. So again, to use the example of Sprintlaw, we have a dual company structure. So we have Sprintlaw Group Pty Ltd, which is our head company. We have Sprintlaw Australia. It's not actually called that, but Sprintlaw Australia Pty Ltd is our Australian company. We have Sprintlaw New Zealand, and we have Sprintlaw UK. And we also have something called Sprintlaw Tech, which is like a software company. So what we've done by creating all of these different subsidiaries, which we've built over time, is we've siloed the risk of each of those operations or business units into those entities. If something goes wrong in Sprintlaw UK, it doesn't affect Sprintlaw Australia. It doesn't affect the holding company. If something goes wrong in New Zealand, it doesn't affect the others. If something goes wrong in the tech company, it doesn't affect the others. So this is why people will often set up these multi-company structures. Not something I'd suggest doing on day one. It could be very expensive to register like 9 companies. But certainly at least the dual structure, which is not too expensive, if you know you're going to expand, just setting things up this way can be neat from the beginning because it gives you the flexibility to do stuff like what I said over the next years. If you set up as a single company structure, it can get a little complicated when you want to start to split it in half because you got to, move all of the employees to a new company. You got to move the IP somewhere else. There can be all kinds of logistical headaches, move the bank accounts, all that kind of stuff. So it can be neater if you can afford it to actually do the conversion either at the very beginning or pretty early on in your journey. So something to think about. Finally, on the right, we have the trust structure. The trust structure is very similar to the dual company structure at the bottom, but you can see up the top, there's a few differences to the middle column. This is more of a personal decision than a business decision, but oftentimes founders and investors will not hold their ownership or shareholding in the company personally as themselves. They will also hold that through another company called a trust company. And there's kind of 2 reasons that you might do that. You can see in this middle scenario, founders are pretty well protected from the employees and the clients. They're 2 degrees of separation away from risk, but they're not that far from each other. If there's a dispute between the founders, they can sue themselves and come after each other's house, home, assets, and so on. So you might actually want to stick another company here, which is what a trust company can be, that sits in between you and other founders and investors. And again, the individual founders themselves are not only protected from employees and contractors, but they're protected from risk as compared to other business partners. So that's one reason it's done. The other reason is, and the reason you don't set it up as a normal company, but rather a trust company, I won't go into great detail now, but there's tax benefits and ways that you can distribute dividends and profits and ultimately sale proceeds from the company more tax effectively, if you will, if you're operating a trust structure. Not something that lawyers advise on all that much, the tax side of things, and it is a good idea for pretty much any serious startup to get an accounting or tax advisor. Certainly, you can use a service like Thriday, which Josh mentioned earlier in your early days, and then potentially a tax accountant of some sort to help you make these decisions around how you're going to manage your trust. So again, using the case of Sprintlaw, this is really the setup that we started with. Sprintlaw Group, Sprintlaw Operations. I have my own trust, the Alex Solo Trust. My co-founder has his own trust, and some of our investors have trusts, some don't, if that makes sense. So that is the advanced company structuring kind of done. If you're not sure about any of this stuff, a great topic to ask for some advice on, because it can get a little complex. But I would suggest thinking about this stuff if you are serious about raising capital and scaling your business sooner rather than later in your journey. You don't have to do it on day one, but if you do leave this, we had a client who ran a now very successful alcohol brand, founded it himself, didn't get legal advice, ran as a single company structure, grew the business, ended up selling it for something like 100 million, and hadn't done the structuring piece. And the difference in his exit value was quite significant. We're talking millions and millions of dollars difference in terms of how it would have played out if he'd had a dual or trust structure. So it can really have these serious consequences. And he was told early on, kind of like I'm saying now, by people, oh, you should sort this out, and just couldn't be bothered. So I would suggest looking at it in the first couple of years of business if you really have these ambitions to grow and scale. If you're operating a small business, it doesn't matter as much, but certainly for scaling companies, it does. So that's company structures. Just moving now on to regulations. A threshold question that pretty much every business should ask themselves: what are the regulations that apply to me and my business? What are the pieces of law that apply? There are some laws that, of course, apply to everybody. We have criminal acts that businesses and individuals can't undertake. You can't commit fraud. We have something called the Australian consumer laws, which say that all businesses must not be misleading and deceptive. Terms, things can't be buried in the fine print, so on and so forth. We have privacy laws that apply to all businesses. So there's a small set of laws that apply to everyone. And I'll talk about some of them on other slides. But in addition to those, depending on your business model and your industry and your product, there may be specific regulations that apply to your business. Now, this isn't actually an area where you go out and get you speak to a lawyer and hope that they'll sort it all out for you. Certainly, lawyers can help you navigate the regulations, but I think it's actually quite important for business owners to know what the regulations are. If you're designing a product and there's product safety laws around your type of product, if you're designing something for children, there's child safety laws. If you're designing pharmaceutical products, there can be risks there too, and requirements around getting things registered with the TGA. Whatever your industry, typically there are regulations. We're in the legal industry, so we have regulations on how we can market ourselves, whether we can accept commission fees, how we accept payments from clients. These regulations go to the very core of how we design our product and service at Sprintlaw. And it was very important on day one, we knew how they worked, because if we just went and built our product without thinking about the regulations, we may have breached some of these laws without realizing them. So I would advise kind of everyone, if they haven't already, to work out what industry am I in, and it may be industries. If you're, doing something in the agricultural space, but there's also a technology or chemical component to it too, there may be multiple potential industries that you may be in. Who are the regulators? And are there any requirements that may impact the design of my product, service, or solution? So just try and be aware of those things. Oftentimes, you can go to regulators' websites and just speak to them directly and tell them about what your business does and say, does that all sound good? And that they can help you really actually navigate this stuff without having to spend a ton of time getting advice on it. If you're stuck on a particular question, you can get legal advice, but just a threshold question of something I think everyone should be thinking about. So that's regulations. Moving now on to contracts. We have this fairly dramatic title: contracts are the lifeblood of your business, which is there because I do think this is the area where a lot of smaller companies kind of try and do things themselves or don't address properly. But really, it's probably the area of law that requires the most attention for early stage companies. And certainly, the bulk of work we do at Sprintlaw is kind of on this slide. We do a lot of other IP and other sorts of stuff, but I'd say around 40% of all work we do is related to the things on this slide. So that gives you a sense of for startup companies, the kind of legal requirements that you may need. As a business, typically you are going to have a ton of relationships with different individuals and organizations. You'll have customers, usually. I think nearly all businesses, not all businesses. have customers of some sort. You know, if you're an app, it's your users. If you're selling tractors, it's the people purchasing those tractors. You know, it doesn't matter what business there are customers of some sort, and businesses often have owners. If you're operating company structure, those owners are called shareholders. If you're operating as a partnership, it'll be the partners. Or if you're a sole trader, I guess it's just you, the sole trader. If there are business relationships, you know, that's another set of relationships. Businesses may have partners, people that refer to them or they refer to. Businesses will typically have suppliers or service providers, people for whom you are their customer. So people that provide you goods and services, whether it's the premises that you operate on, or maybe they sell you goods, parts. Maybe they're your web designers or your graphic designers. You know, people that will either provide you with goods and services, suppliers and service providers as well. So these are all the different sorts of relationships. Now, per my first slide, what you want to be thinking about with all these different parties, what are the risks and where are the opportunities to get better deals? And this is where lawyers can come in and kind of help you manage those things. A lot of what we do is really this first relationship between the business and the customer. Typically with your customers, there's a couple of key things that you want to be thinking about. The first is, how am I going to make sure I get paid and get paid on time? And how am I going to make sure that I reduce my risk if something goes wrong? That's typically what you're thinking about as a business with customers. Now you can just shake hands, sell to a customer and cross your fingers and hope that both of those things happen. Let's hope nothing goes wrong and let's hope I get paid. And certainly if your business is a cafe and you sell coffees, kind of you have to do that. You know, people aren't signing 10-page contracts before they take a sip of a cappuccino, promising. Although I have been to a Mexican restaurant before where they made me sign a waiver before I had their hot sauce. So it can happen, but typically, you know, some businesses, it's just not part of the culture to do that. But ideally, if you want, if you can, you want to have a standard set of terms and conditions with your customers. If you're selling a product, that can kind of be bundled with the product. If you're selling a service and a product or a software or something like that, that can be the terms and conditions or the service agreement, but some kind of contract. And that contract typically will set out what you're delivering, all of the disclaimers of things that, you know, you don't promise this thing might do, and liability protections. If things go wrong, you know, I'm happy to give you a refund, but you can't sue me for $1 million. These things are at your own risk. Only use the product or services in XYZ ways. These sorts of risk protections, if in writing, if signed under the law, can really provide a serious protection for your organization from risk. And second of all, these kind of payment terms. You know, maybe they pay you on the spot so that it doesn't matter as much, but if there is installment payments, invoices, or, you know, subscriptions and renewals, you know, what is the obligation to pay? What happens if they don't pay on time? What are the cancellation conditions and terms, and what are all the different scenarios that could happen? Very useful to have a standard contract to use with your customers, if you can, or at least if it can't be standard, some kind of agreement that you're using with customers. A lot of the disputes we see startups end up in is because they've done a deal with a client and they just haven't even talked about some of these aspects of the service, and it's not enshrined anywhere. And the dispute itself could have actually just been avoided if there was more clarity at the beginning, if there was a document that set out how things work. But because parties are under different impressions and there's no source of truth to determine who's correct, the parties often end up in a heated dispute, and it can in some cases be seriously detrimental or even business ending. So customer agreements are very important. Up the top, we got shareholders, you know, the people that you've established your business with. We often see falling outs between business partners. There's a contract called a shareholders agreement, or if you're a partnership, it's called a partnership agreement. But typically, like I said, most business partners operate under the company structure. So another one of the very common services that we provide is these shareholders agreements. And we recommend, again, you can just shake hands and go on business together, but tons of things can go wrong. What happens if one person wants to leave and the other one doesn't? What if one person wants to sell and the other one doesn't? What if there's a decision that one person makes and doesn't consult the other? You know, what are the rules of what people can do without checking and what requires checking? If you have investors who also become part owners of the business, what are their rights? What can the directors who are running the business or people working in it, do without telling the investors, and what do they need their approval for. All these sorts of situations that can emerge, and there's many of them that can emerge when a company is being operated between a few people. This document, this shareholders agreement document, has kind of a structure or list of solutions to those situations. Now, we've thought through all of them as lawyers. Most lawyers that specialize in this space have the kind of list of, what do you want to happen in this situation? What do you want to happen in this situation? So we can guide you through what's normal, but ultimately you've got to decide and talk it out with the other business partners. Hey, if in 3 years' time I want to leave, what's going to happen to my shareholding if you want to keep working? And we can put all of that in the document. It's all agreed, it's all signed. And then a lot of the tension that can emerge in the future as the kind of business marriage progresses can be, I won't say fully solved, but certainly significantly reduced by having these rules in place kind of early on. So that's another kind of key document. We've got the customer agreement, the shareholders agreements, and those are probably the two, if you had limited legal budget, and I would suggest getting done right, the customer agreements and the shareholders agreements. The other documents, are depending on your business model, often less business critical early on, but there are some exceptions to that. So let me talk about the others. So service providers and suppliers, people that are designing, let's say your software, or providing you with the lease, or et cetera, they're also going to give you contracts. Typically, you're not going to give them contracts. You might sometimes. You might have contractors that you give contract agreements to. We'll cover that again in a moment, but oftentimes you're their customer. They've got their customer agreement, and they'll come to you and say, hey, I'm happy to provide you with this property, this lease, or I'm happy to provide you with this web design service or app design service or this manufacturing service or whatever it is. Here are my terms and conditions, and they're going to give them to you. A lot of people will just say, thanks, sign, accept, pay, and go into business with them. Of course, the terms of those agreements are very rarely designed to be in your favor as the customer, because whichever lawyers drafted them, I can certainly tell you, if it was Sprintlaw, I would have designed those terms and conditions to say, hey, customer, I know you're paying me money, but I'm not liable if anything goes wrong. And if you don't pay me on time, I can stop supplying the services, et cetera, et cetera, et cetera. And maybe that's okay for small scale supplies, but if you have a key supplier agreement or a key service provider, which your business relies on to exist, or it's critical to your operation, maybe it's a good supplier, maybe it's a manufacturer, maybe it's a software developer, that contract actually matters a lot, particularly if you're spending a lot of money on it. You want to get guarantees that you're getting what you paid for. You want to be sure that if there's some problem, they're going to be there promptly to help you solve it. You want to be sure that you can get a refund if there's some defect with what they've done. And if they're wildly negligent, you may want actually them to, be liable, and you be able to sue them if they cause your business significant harm. So for those key relationships, and I'm not saying every single one, if you use Microsoft Office, they're technically a supplier, but you're not going to call up Microsoft and negotiate those terms and conditions. But if there are key suppliers of goods, parts, or software, or something else, or even a lease that's critical to your business, these things you might want to get reviewed, checked, and edited, just to make sure that it protects your business and you've got some recourse if things go wrong. And then finally, we have partners, people that you refer to or refer you work to. Again, a lot of partnerships are done on a handshake arrangement, hence the icon we have on screen, without contracts, which again, I don't have a huge problem with doing in the early stages. But again, if you end up with these key partnerships where a lot of your work is coming from one source, or you're referring a lot of work to another source and getting a commission or some kind of payment for that, and it becomes important to your business model, again, you just want to secure those revenue streams, secure that relationship. And maybe there's a clever way to design your partnership arrangement where your partners referring to you can be better incentivized and might actually increase the amount of referrals that come through. So again, you can put in place what's called a partnership agreement, to be distinguished from the other partnership agreement we're talking about. I prefer to actually call it a referral agreement, so it's less confusing, but a referral contract or some kind of affiliate partnership agreement with people that you work with can be a really good thing to put into place for your company. So those are the I guess main type of contracts that you may want to be thinking about. Let's move now on to intellectual property. This is another area that a lot of startups are thinking about. Intellectual property refers to really the intangible assets of your business, things that your business owns, but they're not in physical form. You can't feel them or touch them, but they're essential to your business, and you want to make sure that you kind of own them. And there's kind of 4 or 5 main types of intellectual property that most businesses are thinking about. The first is trademarks and designs for logos and brand names. There's copyright for original works. There's NDAs for information, not really IP technically, but it's kind of part of the whole story. And then there's patents or patents, depending on whether you're English or British in terms of how you pronounce it. But so I'll talk about each of these in a little bit of detail. Trademarks, to begin with, as I mentioned, they're a way of protecting your logo or your brand name. So, for example, Sprintlaw, we have our name, Sprintlaw, is our brand name, and we have this little S-shaped object, which is our logo or our logo signal. So when we came up with this name, we wanted to make sure that we owned this name, that someone else couldn't come along with something called Sprint Legal or Sprint Lawyer and pretend that they're kind of us. And we wanted to own this insignia, and trademarks are a tool for doing that. The way that trademark ownership works is it's possible to register with an Australian organization called IP Australia the exclusive right to use a phrase, a logo, a catchphrase, provided it's limited to a particular country and a particular industry or class, they call it in trademark terms. So we've registered the word Sprintlaw and a little S logo as 2 trademarks in class 45, which is the legal class in Australia. We've subsequently also registered another trademark in the UK, another one in New Zealand. We just got one in the US. We got one in Canada as well. So we own the right to use that name, logo, phrase. That means no one else can use it. And that gives us confidence that when we're designing, growing, promoting our brand, it's ours. We know it's ours. And there's not someone who's going to come out of the woodworks and go, I had that name before you, and it's mine. Now, a common misconception, obviously, when you register your ABN or register your company name, you got to pick a name and it can't be the same as another name that's out there. A lot of people think, oh, I've got my name already. I got it when I registered my company. That is not a trademark. That's just a kind of registration requirement that will get you, through the front door of having a company. But a trademark actually gives you a right to the word and the brand name. For example, there's a large law firm I used to work at called Clayton Utz. Their company is probably called Clayton Utz Pty Ltd. They could start a department called Sprintlaw, and they could have registered a trademark for it that just does some kind of fast law thing. And even if I'd registered Sprintlaw Pty Ltd, I could have on day one be infringing their trademark. So there's a difference between company names and brand names. They're different, and you got to secure both. And it's the number one issue that we see for startup companies in particular is they come up with a cool brand name. They don't register it as a trademark early on. They invest time, money, effort, printing products, manufacturing things, promoting it, growing it, only to find out either they can't get it protected or someone else owns it or someone else owns something like it. Because trademark law is not just exact match. We wouldn't have been able to get the trademark for Sprintlaw if someone has Sprint Lawyer or Sprint Legal. There's a bit of nuance to it. So they grow their business, they grow their brand, and then they find out they're infringing someone's trademark and they have to change everything at a huge expense to the company, where they probably shouldn't have called it that in the first place or found a way around it early on. So definitely, the first 2 things we did when we started Sprintlaw was we registered our company and then we got our trademark. Like everything else kind of came after that. Shareholders agreement was next, but that was kind of our 1-2 in the to-do list. So if you haven't got one already, but you do have a name, I would recommend securing it. Really important way to protect your kind of name and logo, and catchphrase as well. If you've got, ours is business legals made simple. So we've got that registered somewhere as well. And there's something else called designs. They're a little different, but you can register product designs. You can register the shape of furniture or the shape of construction materials and other sorts of things. If the shape is original, and the design is original, again, you can get an exclusive right over that structure or blueprint, for a certain period of time without too much trouble for IP Australia. So if you're designing physical products that have a kind of unique design, and you want to own it and you don't want to see other products copying you and coming out on the market, there is this registration for that as well. And again, people that are designing products often use that registration. So that's trademarks and designs. Second one we have is copyright. Copyright refers to any original work that's recorded in material form. So what that piece of jargon means is any kind of creative works that you come up with in your business or otherwise. These may be things like books or documentation or graphic designs or even original processes, procedures, or presentations, or other collateral that you may come up with in your business. If there's software, often the software code is considered a creative work as well. Any of this creative original work is considered copyright. And typically, if there's important stuff in that category for your business, you want to make sure that you own it. That's one of the critical aspects of copyright. Now, unlike trademarks and designs, where you go to ipaustralia.com, you lodge an application, you pay a fee, and then you own it after a period of time. With copyright, there's no registration. Copyright is owned by the author the second it's created. So if an author writes a book, the second they finish that final sentence and put the full stop on it, at that moment is owned by the author legally. And if someone else were to copy that or copy a substantial part of it, plagiarize it, which is not a legal concept, but copy a substantial part of it, that would be considered to be copyright infringement, even though that person didn't register it. It's owned by the author at the moment of creation. So, for example, in the business context, this presentation that I'm doing, assuming you would agree that it's original and there's a legal definition of that, the moment it was created by me and recorded in digital form, it was owned by me as an individual. So that's where this can come up in business. Now, obviously, when you're operating in business, you're, as we mentioned earlier, typically you've got a company. You don't want the author to necessarily own it. You want the company to own it. You don't want your employees owning every little piece of work they did for you. You don't want your graphic designer owning the designs they did for you. You want to make sure your business owns its copyright. And because there's no registration process, the only way to get copyright ownership is through a contract. And this is why, again, contracts are the lifeblood of your business. Typically in your employment agreements with employees or your supplier agreements, service provider agreements, whoever you're paying to generate this copyright, there needs to be a paragraph in there called a copyright assignment paragraph, which says any work that you do for me, whether in the past or in the future, is hereby and always assigned from you, the individual, to the company. So for example, I have an employment contract with Sprintlaw. There's a paragraph in there that says any work created by Alex Solo in the course of his employment with Sprintlaw will be hereby in the past and future owned by Sprintlaw Pty Ltd. So what happened was I created this presentation. I hit full stop on it. It was owned by me, I guess, for a split second, but then it was transferred to the company. So the company, in fact, actually owns this presentation. And again, you want that to happen with your employees, your staff, and contractors, and anyone else that creates original work for your business. Robert's just asked a good question. What is the remedy for breach of copyright? Look, if somebody has taken your original works, first of all, you got to prove that copyright exists. Because there's no registration, it can be a bit subjective. Was what you had original? Was it recorded in material form? But provided those boxes are ticked, there's a claim you can make for infringement of copyright, and you can sort of commence action against someone. You can say, you're using my stuff. This part you've taken is a non-trivial part of it. It's a substantial part. You can sort of make a claim, and if it went to court, which you may not, because you may settle earlier, you can make a claim for what's called an account of profits. If they've made money off your copyright, they've profited, they've licensed it, they've done something, you can have those profits that should be yours because it traded off your intellectual property. You can also sue for damages as well. So if they've caused you loss, you've lost customers, it's diluted your brand, you can make a loss-based claim or a combination of the two. So really the way the remedies often work is they're intended to put back the person that suffered some kind of infringement in the position they were as if it hadn't occurred from a damage perspective, and also to give them the advantage that they should have gotten had this been done properly, which is the account of profits. So that's kind of how it works. Robert said, do you trademark or copyright by saying powered by live bacteria? So there's no requirement to use that phrase. You see TM or the little R symbol sometimes. You see that on logos, and and which indicates a trademark. And sometimes you see on websites or on documents, copyright 2024, Sprintlaw P2 Ltd. Those phrases are not a requirement to use, but they are not a bad idea for a few reasons. One, for copyright stuff, copyright is automatically owned by you when you create it. You don't have to write anywhere that it's copyright, but a customer may not know that something is copyright protected, or may not know that you're treating it as copyright. And by actually having that copyright 2024 XYZ on the important document, it puts them on notice in practical terms that this is your copyright. You consider this your copyright. And if they're copying it, there may be infringement, and it'll actually help in a legal claim, because part of a legal claim is not only showing that it was copyright protected, it was original and recorded material form, but also that the person infringing kind of knew that and took it anyway. It's not essential, but it does help the claim. So by putting that piece of writing, copyright by XYZ, it helps put them on notice and will strengthen a claim. Powered by the words you've used there won't actually achieve that, as well as using the word copyright. The law would prefer the use of the word copyright. So it's not essential by any means. I certainly haven't done it on this presentation. I might, maybe on the disclaimer we've got something here which is similar, which says all materials are subject to copyright and other intellectual property. So this is the equivalent of writing kind of what you just said. But it's a good idea, and certainly on our website and in other places where we have copyright materials or things we think may be copyright, we do say that. For the trademark, it's a similar thing. You actually can't use this little R symbol until you have a registered trademark with IP Australia. Otherwise, it's actually a breach of the law to use the R symbol for your brand name. You can use the TM symbol while you're waiting for it to be registered or at any time, but the R symbol is a regulated symbol. But again, not essential, but does, first of all, it just looks good and it gives you a stamp of credibility and shows that you're a serious organization. That's why a lot of people do it. And second of all, it can help put people on notice that this is your trademark, and again, strengthen a claim a little bit. So we don't actually do it with Sprintlaw because we don't think it helps the design, and the benefit on trademarks is not as much as on copyright because there's literally a registration we have, but it's up to you if you want to use that kind of R or TM symbol. So yeah, great questions on copyright. Moving on to NDAs. NDAs, non-disclosure agreements, also called confidentiality agreements or confidentiality deeds. They're not really about property, but I like to bring them up here because oftentimes your business will have kind of important ideas or concepts or strategies which are crucial or critical to the business, which you don't want to share with other third parties. You don't want other third parties to sort of take, monetize, or commercialize. Now, these things may not protect copyright, and it may not be copyright protected because one of the hallmarks of copyright is that it has to be an original idea or concept that's recorded in material form. It needs to be written down, and it's the material form that's protected, not the concept in copyright. It's often said there's no copyright in ideas. So, you're watching this presentation. If you copied 2 slides, that may be copyright infringement because you've copied the material form. If you just listen to this presentation and you make your own presentation, which uses none of the same words and logos as my presentation, you're just kind of inspired by it, there's no copyright infringement. I can't say that there's copyright infringement because you copied the underlying concept. You didn't copy the actual material form. So copyright is limited in that sense. It only protects the material form. So NDAs are broader. They're basically a contract that often says anything I'm about to tell you, you can't tell anyone. And if you tell anyone, you're breaking this contract. And not only can you not tell anyone, you can't commercialize it, monetize it, or do X, Y, Z for a period of X time, or you're breaching this contract. So it actually doesn't rely on the laws of intellectual property. It relies on a private contract between you and the person. And it can be a really effective way to just protect yourself from information you're sharing with people that may not have copyright attached to it, but may still be important. So typically, startups are using NDAs when they're talking to potential suppliers, potential manufacturers, even meeting with competitors. They're a bit nervous about what they're sharing, or they're worried that a manufacturer will run away with their idea and tell someone else. You can just have a template, 2-pager NDA, which gets signed, and really just means you have some security if they go off and steal it, that you could sue them for a breach of NDA. And again, the act of signing that NDA is often a large deterrent for people to do things, even if you may not have to sue them. You may have just deterred them by giving them the NDA. So it's a simple, very, very simple document. It's one of the few areas where, unless it's really, really high risk or complex, you can often just use an online template for these things. In our membership, we give away, I think, a free NDA template. So worth just having one and using it to protect yourself in those situations where you're a little worried about the information you're providing. Of course, it can be overkill. If you're just having a simple meeting and you pull out NDAs, it can ruin the vibe of the conversation. So I'm not saying go everywhere with an NDA in your pocket. At Sprintlaw, we use it only for major projects with like software developers or like investors. And not even in my first meeting, I would use it with investors before I give them all my financials, but not before I even just have a chat to them and show them my deck. You got to be, I guess, willing to share a little bit sometimes to make a conversation happen. But again, the NDAs do provide that protection if you get them signed. Finally, on patents or patents, these are a registrable IP right for inventions. So things that you come up with that have never been discovered before. There's a fairly high threshold to register a patent. It has to be sort of not published anywhere in the world. It has to have never been disclosed before and have to be something that you came up with. And while copyright has this threshold of originality, which just means it's a little creative, the threshold for patents is inventiveness, and it needs to really be a true kind of human invention that pushes forward scientific progress. So it's difficult to get a patent. It can be expensive as well. You need to have it assessed. When you apply for a patent, you say, here's the invention that I created, and here's why it's never been done before, and here's what it is. You actually disclose all of the commercially sensitive information about the patent, which can be a little risky to do to the patent office. A subject matter expert will assess the patent and tell you whether they think it's truly original, truly inventive. And if they approve it, you get a monopoly over your invention, which is a very strong right to get in capitalism that's built on competition. You get a monopoly on this invention, and no one else can use it and use your invention for a period of, it can be up to, I think, 25 years. There's something called innovation patents, which are a little shorter and easier to get, but typically, cannot be used by anyone for up to 25 years without paying you a royalty or license fee or without your permission. So if you do have an invention and your business model is to, I guess, license it to other people to use your invention, it can be actually essential to get a patent. It's a really good way to commercialize it and make sure that you're now licensing something to, and you have this real bit of commercial value that you're licensing to people. Of course, the thing with patents is, when you get them, you got to publish them publicly and explain how they work. And unless you have the money to enforce them, it can be a little risky. People could just look up your patent, and if they can steal your idea, technically they're liable, but you may never know, or you may never find out. It can sometimes be safer to not register a patent and keep your secret source a true secret if you don't have the power to enforce them, rather than registering them. It's often a nuanced decision for inventors as to whether they go through the process or not of registering a patent. But certainly things like pharmaceutical products, the COVID vaccine obviously was patented and then licensed to a ton of people to distribute. Innovative machinery, robotics, and other sorts of inventions are all things in that category of patents. If you've got something you're not sure whether it's patentable, most patent attorneys are pretty good. They'll just chat to you on a call and they can tell you really within 5-10 minutes whether there's some prospect of getting it patented or not. And then if they think there is, you can invest the money and begin the process if it feels right for what you want to do. Awesome. Just conscious we've only got a few minutes left. So I may just touch on the data and privacy stuff and then leave a minute or two for questions. And then we can kind of wrap up. But just quickly on data and privacy, this is obviously a hot topic for businesses since the Optus and Medibank breaches that happened last year. To just wrap it fairly quickly, when we're talking about privacy law, we're talking about the collection of personal information. So that's people's name, contact contact details, address, phone number. Anytime you hold people's personal information in your organization, that is where the laws of privacy come in, and they talk about, well, what you have to tell them when you're collecting it, what you can and can't do with it without their permission, and what you got to do if there's some kind of breach of their personal information or data breach. The most essential thing for compliance is to have a privacy policy in place for your startup or small business, and it basically would set out as you put that together, set out the processes and procedures you follow, both in relation to data breaches, but also in relation to how you're collecting it, what you're going to use it for. As long as you're getting people to consent when they provide you their personal information, whether it's on your website or whether they consent, when they give you their details in person, you're going to be pretty far towards complying with the Privacy Act. And then, of course, if something goes wrong, as soon as you suffer some kind of data breach, which hopefully won't occur, there are procedures you have to follow relatively quickly to let them know and let the regulator know. And if you comply with those procedures and it's not your fault, you may not be liable. But if you don't comply with those procedures, or you were very negligent in the way you handle their personal information, you can potentially be liable. So it's an area of compliance that can be very important to businesses. There's exceptions for very small companies at the moment, which are probably going to be abolished soon, which make it a lot easier to comply with the privacy laws. But it's certainly an area that pretty much everyone should look into. And it's not really a legal point, but we have seen a big rise in cybercrime, cyber theft in our clients in the last couple of years. So getting cyber insurance, and if any digital places you hold people's personal information, making sure you have some IT professionals lock it down and secure it is also just a good idea. Help reduce risk, reputational damage, and all the things that can go wrong if you suffer a data breach. But again, from a legal perspective, very much the two things are get a policy in place, a privacy policy in place, and make sure you're aware that if there's an incident that occurs, you reach out to lawyers kind of straight away. So I might wrap it there. I don't know if we're kind of on to, I'm happy to take a couple of questions if anyone has any. Assuming that's okay, Josh, or yeah.
Yeah, no, absolutely. If anyone has any questions, please do feel free to ask out.
Yeah. Thanks for that, Alex. I really enjoyed that and found that helpful. I've just got a couple of short questions. I'm currently under a single company structure. It's going to be pretty easy for me to go to a dual company structure, but in terms of bringing in that trust format, does that get more difficult and expensive the more valuable the holding company becomes in time?
It does. It's a really tough decision. One of the most common questions we get from startups is, should I go all the way to trust from day one? Because then it's expensive to set up and maintain. And it is annoying to maintain. Like you probably want accountants to do the returns for you, given the amount of admin involved. But equally, if you leave it too long, there's tax consequences. I would just have a chat about it with your accountant and ask, should I do this now, or when can I put it off till? Because you do want to put it off as long as you can. But my understanding, and again, I'm not a tax specialist, is if your company is actually worth something and you want to transfer the shares from yourself to your trust, it can be a CGT event. And if the company's worth $0, there's no CGT event. And there's some exceptions, but if it's now worth $1 million and you transfer it, you got to pay money the time that you restructure. And that's the risk of leaving. It costs a lot more later. And that's what happened I told the story of the guy that waited too long to do the trust. He kind of realized a few years in, but his company was already worth several million. And he's like, I don't want to pay the cost. I can't pay the cost to restructure now. So I'm stuck. We didn't set up at Sprintlaw with the trust. We went about 12 to 18 months without the trust, just the dual company. And then we started to generate a bit of serious revenue. And at that point, we said, okay, we need to restructure, because we knew if we waited too long, there'd be a cost. The accountants managed to do it for $0 and it was fine. So you don't have to do it tomorrow, but I would do it pretty early on, and you can chat to your accountant to work out the perfect time. Yeah.
No worries. And it was just one other short one. I got that logo done by AI. I've been told that it can't be a trademark because it wasn't done by a natural person. Can I get it just a minor alteration made to it and then apply for a trademark on it?
So that's actually not true. What you were told about the natural person thing, at least. Maybe actually that's an interesting question. I think copyright ownership is this, because there's copyright and trademark. My understanding right now is there's difficulty around showing that you own the copyright in that, because I mean, first of all, that whole area of AI design is very gray as to who might own that. But I don't think IP Australia ask you the question, I mean, they certainly don't ask, was this generated by AI? They just ask you a question as to, I guess, whether you own it or whatever. I think you can probably register a trademark for it. That doesn't mean that if that was generated, the AI copied someone in America's like graphic design portfolio, they could possibly get you for copyright infringement, even though you own the trademark, which is a different claim. The more you alter it, the lower that risk is. So I guess it's a decision for you as to whether you think that's likely to happen. Yeah, I know. I mean, a lot of graphic designers are using AI tools kind of in the background, and people are registering things as trademarks. So I don't think it's a deal breaker for you. But there's probably some risk because you just don't know where it really came from when you use the AI. So yeah, if you need more advice on that, you can chat to my team. But that's kind of my initial thoughts on that question. Yeah.
No worries. Thanks for that, mate.
Awesome. Any other questions?
Yeah. Hi, Alex. It's Rob here. Can you hear me okay?
Yeah. All good.
Oh, very good. Privacy policies. While you were talking, I looked at 3 of our websites and none of them got privacy policies put on them. They used to just be on their normally our tech guys would put them on just using a plugin. They haven't even done that this time. Would you recommend using a plugin or go and get something made up for each organization?
I wouldn't recommend a plugin because sometimes, I mean, it's hard. Like it could work, but a lot of the plugins are like American privacy law or some generic non-Australian compliant policy. I touched on it at the end. Currently, as of today, there is an exception for businesses under 3 million in revenue where it's not a legal requirement to have a privacy policy. So, but I suspect there's a lot of talk that that's going to be abolished within the next 6 months because of all of the talk around privacy. And anyway, if your businesses do exceed, I don't know what they are at now, but if they in the future may exceed 3 mil, it then becomes problematic because you need to have had consent from everyone on your mailing list from day one and every client from day one. So really, it's a good idea to get it done on day one. So yeah, I would recommend if you can afford it. It'll probably be the same unless the businesses are radically different. You may just have to pay for one and you can use it for all 3. But getting a proper one kind of done. And then you're kind of future proofed and it's all kind of set up, and the web designers can just put it in the footer or whatever it is. Now there's these pop-ups that you see, when you land on websites now that says, we're tracking you. There are cookies on the site, and do you consent? Those pop-ups are actually an English law, European law requirement. We don't need them in Australia. They're certainly fine to have. It's again possible in 6 to 12 months that will become a requirement of Australia, so you can do it if you want. But the only requirement in Australia is that in your footer and when you have those contact forms, name, email, address, submit, there's a tick box or a sentence there that says you agree to our privacy policy when they submit the form. And then again, there's a page in your footer that has your privacy policy. So if you don't have that, I'd get that set up, a proper drafted privacy policy on your site and either a tick box or a notice on the submission forms. If you want to do the pop-ups, you can, but they're not essential yet.